said, I know both cases are listed, but the payments were being paid. Sarah should be in.
Okay. Mr. Murthy, are you appearing on Mr. Gahn's case?
I am, Judge, because I got a notice, but my representation, my understanding is terminated after sentencing. This is just a review matter, and the court, I think, has scheduled reviews going forward. So I keep getting notices, so I'm here for that.
Okay. All right. Thank you.
Unless the court tells me I don't have to appear, but I'm here because of the notice.
Okay, and I would agree. I don't think you're attorney of record anymore, so you're free to disconnect if you'd like to, and I think that it still may be listed in the file when Jen generates the notice. And
okay. And Judge, I'll just stay on because we've got a 145 that just got added to your docket.
Okay, thank you.
Right. Thank you.
Thanks, Randy.
Ms. Koch, are you able to hear me?
I am.
All right, and the record should reflect, I see that Mr. Grogoski is connected as well, so we'll go on the record. Two different files, People versus Arthur Gahn, that's file number 235160, and then Mr. Grogoski versus Mr. Gahn, case number 2311370. This was set as a review hearing today. The court has been continuing to monitor payments by Mr. Gahn on restitution. The information I have, Mr. Gahn, you just made a payment of $100 today, is that correct?
Yes, sir.
Okay. So Mr. Gahn made a $100 payment today. Ms. Koch, is there anything that you needed to add to this?
Your Honor, I do not have any additional information as our office doesn't receive or track the payments. I did speak briefly to Mr. Gahn. I saw him in the courthouse in a different matter. He said that him and Mr. Grogoski's relationship is getting better from his opinion, and he was happy about that. I don't know if that's true, but he seemed positive about their relationship as neighbors. I hope that he continues to make the payments. I think that definitely will help. Thank you.
All right, Mr. Grogoski, was there anything that you wanted to state today? You're muted, sir, so you need to unmute.
Yes, Your Honor. Can you hear me now?
I can, thank you. Yep, go ahead.
Thank you, Your Honor. As far as the terms of the relationship, I am not in Michigan at this moment, but prior to me leaving, I have had several interactions with the Crawford County Sheriff's Office due to Mr. Gahn and his children. So that relationship has not gotten any better. I still stand on my position. Mr. Gahn came in today because it's a court day to make a $100 payment. We're still looking at about a 15-year period before I am made whole from the decisions that he illegally made. Also, Your Honor, I think it's the court should know, I brought this forth several times to the prosecutor and to the court that this case was always tied to a substance abuse case with alcohol and drugs. Mr. Gahn has continuously done that. He's now under in the 53 Circuit Court. He has a felony case pending for a DUI and also felony assaulting a police officer. That just keeps moving forward. it continues to get worse with him, not better. And I understand that this court probably doesn't have jurisdiction at this time to go back and address those things that a deaf ear fell on from the beginning of this case that I tried to present. But I just still give my, from this case and from a victim, I just don't see how it takes 15 years, 12 to 15 years to pay off $1,500. How justice is being served, and I've said it before, I'll say it again. Justice delayed is justice denied. Justice is being denied in this case, and Mr. Gahn continues to break the law in severe ways. And it just seems to slip through the cracks. And none of the courts kind of want to hear that or understand that.
All right, thank you. So the court's role here is to make sure that Mr. Gahn is continuing to pay. And Mr. Gahn has provided information to the court in the past regarding his ability to pay. The court is limited in terms of what it can do in forcing Mr. Gahn to pay all of the amount up front. The court has contempt powers, but the legislature has limited my ability to put Mr. Gahn in jail for not paying based on his ability to pay. The court can only require him to pay what he's able to pay without, as the statute says, without imposing a manifest hardship. So while I certainly sympathize with you, Mr. Gergoski, I wish I could make Mr. Gahn pay all of it today. If for no other reason, then I don't have to keep calling him and you into court. So believe me, I would just as much enjoy seeing this matter put to rest as you would. Now, all of that being said, all of that relates to the court's ability to force him to make cash payments here as part of the restitution. As you may or may not know, Mr. Gergoski, restitution orders are enforceable as civil judgments. That's something that the prosecutor's office, through the crime victims advocate, should be able to give you some information on. Ms. Koch's office has the ability to seek enforcement of restitution orders as well, which could include seizing property, seizing assets, those kind of things. That's outside of the jurisdiction of the court, but that's something that you on your own or through the prosecutor's office could seek to do. If you believe that Mr. Gahn has property or assets, you can take action to seize those. So there's a number of different avenues that could be explored here to the extent that you're unhappy with or dissatisfied with, and I totally understand it, the amount of money that the court's able to collect. So Mr. Gahn is continuing to make payments. That's all that I can legally require him to do, given his circumstances. And so we'll continue to monitor his payments. Mr. Gahn, you need to continue to make payments.
Absolutely. Yes, sir. I would love to pay the whole thing off too, because I want this whole thing put behind me also.
None of that's here or there.
Right,
So,
right. And that's why I brought the information I brought. So I'm doing the best I can, Your Honor. And he said it was going to take 12 years.
none of that, I'm not going to argue over that.
I don't understand that if I'm paying it $100 a month.
I'm not going to argue.
Okay.
That's neither here nor there.
The other things he's saying are not true.
I don't know whether they're true or not.
I was just letting you know they are. I can prove
None
it.
of it has anything to do with the collections. You need to keep
Thank
making
you.
payments, and that's all
Thank
that
you.
needs to happen as part.
Can I say something?
Thank you, Your Honor. And I would
So-
only ask that we do have another hearing in the future with all the other legal problems that are going on, to make sure that these payments are made and to stay on top of them. And other than that, Your Honor, I appreciate all your help with everything going forward in the case.
And I will continue to do that, yes.
Thank you, sir.
Mr. Gergoski, so I sent out a check to you in October and it came back with an undeliverable. Apparently you have left for however long. So if you don't mind, when you come back, you need to make sure you let me know to update your address so you can get your checks timely. So, because hopefully you got the one that I mailed back out on 11/13.
Yes, ma'am. Thank you very much for contacting me. And again, I apologize. We were traveling quite a bit before we got back. Appreciate the phone call, and I will in the future 100% try to keep up with it. And it's difficult with the mail forwarding and all that, but keep up with in a timely manner to let you know where I am.
Okay, so
Thank
just
you.
so you know, I will send it to the last address I have until you tell me otherwise.
Thank you very much.
Thank you. That's all today. Mr. Gergaski, Ms. Koch, you're free to disconnect, and Mr. Guy, you're free to go for today. Thank you.
I think we're gonna need Ms. Koch just for the 145.
Oh, that's right. Okay.
Thank you, Colin.
Is this Mr.? Nichols, if I can have you come up to the podium there, please.
Judge, is Mr. Nichols being brought over or, okay, I see him.
Yeah, he is here.
My other question, Judge, I'd asked earlier was, would you accept the plea? It's a Judge Hunter case, but I don't know if you would accept the plea. We had this matter resolved, but Mr. Nichols did not appear, so I think we can.
I can do that. And once we get to that point, I'll need to inquire of Mr. Nichols because he'll have to waive sentencing judge.
Correct.
But outside of that, I don't have an issue taking the plea.
Okay.
So we'll go on the record. This is People versus Nichols. We have two files here, file number 235219 and 245340. The record should reflect Mr. Nichols is present here in the courtroom today. And if counsel can put your appearances on, please.
You're muted, Sierra.
Yeah, Ms. Koch, you're muted. Is it not letting you unmute?
Did it work? Sierra Coke on behalf of the people.
And thank you, Honor Ravigar Murthy. I'm appearing on behalf of Mr. Nichols in both files.
Okay, for the record, we're here for arraignment on two bench warrants for Mr. Nichols' failure to appear for a hearing earlier this week. But Mr. Murthy, you indicated there's a resolution that's been reached.
That is correct, Judge. And in lieu of that resolution, I would ask that we dismiss the bench warrant and that the court would proceed further by way of a plea in both files. I think that would be an appropriate way to handle it.
Can you tell me what the terms of the agreement are?
Yes, Judge. So in the older file, 235219FH, Mr. Nichols would be pleading to an added count 2, use of controlled substance. That fact code is 777.74042B. And in the new file, the 2024-5340FH, Mr. Nichols would be pleading to count 1, controlled substance possession of methamphetamine, 10-year felony, count 2, and count 3, the prisoner processing contraband in jails, and assault resisting obstructing a police officer would be dismissed.
All right, and that's a 1-year misdemeanor, the use of controlled substances?
Yes.
Ms. Koch, is that a correct statement of the plea offer?
Yes.
Okay. And Mr. Nichols, have you had a chance to speak with Mr. Murthy about this plea agreement?
Yes,
Is that how you wanted to proceed today?
yes, please.
As best you can you raise your right hand? Solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth to help you God?
Yes,
Thank you. Mr. Nichols, are you currently on any probation or parole?
no,
Right, and you understand that you're going to be pleading guilty, as Mr. Murthy indicated, to 1 count of use of a controlled substance that's a misdemeanor that carries with it a maximum possible penalty of up to 1 year in jail. Do you understand?
yes, sir.
And then you're also going to be pleading to 1 count of possession of methamphetamine That's a felony that carries with it a maximum possible penalty of up to 10 years and or a $15,000 fine. Do you understand that?
Yes, sir.
With those, Mr. Germerthy or Ms. Koch, did the newer offense occur while he was on bond? Is there a discretionary consecutive sentencing possibility?
That is correct.
Yes,
So, Mr. Nichols, in addition to those maximum penalties, you should understand that while the court's not required to under the law, because one of these offenses occurred while you were on bond, the court would have the option of scheduling, sentencing you back to back or consecutively. You understand?
I do.
With all of those things in mind, what is your plea to each of those charges today?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. The right to testify at a trial yourself if you want it. Do you understand all those rights?
Yes.
Understand that you're giving up and waiving all of those rights by pleading guilty.
Correct.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you would have to ask for the Court of Appeals to hear your case. They could say no, and then wouldn't be able to go any further with that appeal. Do you understand that?
I do.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we said here in court?
No.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty because you are guilty of each of these crimes?
Yes.
Looking at the older one, that goes all the way back to June of 2023, June 20th. Do you remember that day?
No, not specifically.
Okay. Do you recall that was the day you were arrested for possessing controlled substances?
Okay, yes.
You do.
Yes.
And at that time, were you here in Crawford County?
Yes.
And when you were here in Crawford County at that time, you had possession of some type of controlled substance. Do you remember what it was?
I don't know.
Okay. Ms. Koch or Mr. Germerty, you know what the substance was? This is an older file.
Suboxone.
Suboxone. Okay. Do you recall that?
I do now, yeah.
Okay. And did you have any legal right to have that Suboxone at that time?
I did not.
And then moving forward to October 3rd of this year, were you here in Crawford County on that day?
Yes,
On that day, did you have possession of some methamphetamine?
I did.
Did you know that that's what that substance was?
Yes.
Did you have any legal right to have any amount of it at that time?
No.
Thank you. Ms. Koch, are you satisfied with the factual basis?
yes, Your Honor.
Mr. Germerby?
Yes, sir.
Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Germerby?
Neither is the defense, Judge.
Ms. Koch, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
I agree.
Mr. Germerby? Thank you. Mr. Nichols, the court finds that your plea is knowing, voluntary, accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea as to full. We'll set this matter for a sentencing hearing, and you're going to meet with the probation department prior to that hearing, probably today. So
Okay.
present your report, and then you'll have an opportunity, of course, to speak to Mr. Germerty, your attorney, for sentencing.
Okay.
Can I get that PAC code one more time?
Yeah, Mr. Germerty or Ms. Koch, do you have the PAC code for the use additional count 2?
I do. 777 dot 74042B as in Bravo.
That is correct.
Okay, thank you.
Your Honor, is the court dismissing the bench warrant at this time that when Mr. Nichols could be out?
As to any additional contempt sanctions, because, you know, this is Judge Hunter's case, I'm just gonna enter not guilty plea on Mr. Nichols' behalf with regard to the failure to appear issue. I'm gonna let Judge Hunter determine how he wants to handle that. I'm assuming in light of the plea that he would dismiss it, but I'm not sure exactly how he likes to handle these, so I'm gonna
Okay.
allow him.
And would the court inform Mr. Nichols that the sentencing judge would be a different judge? It would be Judge Hunter. He's aware of it, but I think it's just necessary for the record.
Right, so do you understand, Mr. Nichols, that you would have the right to have me pronounce sentence because I'm the judge that's actually taking the plea, even though these cases are assigned to Judge Hunter? Are you willing to waive that and have your sentencing heard before Judge Hunter?
Yes, that's fine.
Thank you, Judge.
Yep. Ms. Koch, is there anything else we need to address on behalf of the people today?
No, thank you very much.
Mr. Germurthy?
No, thank you, Judge.
All right, so the court, for the record, Mr. Nichols, your bond was revoked as part of the failure to appear in the bench warrant, so the court's going to order that you remain lodged until the time of sentencing. That's all. Thank you. Okay, and folks are here on the Schroer Family Trust versus Cox matter. Can you tell me your names, please?
Charles Fortino and Sheila Fortino. We're here on the, who was that? Yeah, that's the one.
That's the one, okay. And are you guys actually parties in this?
We are
case?
defendants, yes.
Okay. And you're appearing without counsel, is that correct?
Our counsel will be, it's right there, Larry.
Okay. You do have an attorney?
Yes, we do. Yeah, we're part of the group,
Okay, good.
but we live here full time and this is very important and we just wanted to be here first.
Sure, of course. Let's go through counsel here. Mr. Carey, are you able to hear me okay?
Yes, Your Honor.
And Ms. Keener? You're muted.
Yes, Your Honor. I'm
Okay.
here Oh.
Nope, go ahead. Who are you here on behalf of?
of Stephen and Tracy Jones.
And Mr. Opaleski, you unmute and tell me who your clients are.
Yes, good afternoon, Your Honor. I am here for the Frank M. and Lisa M. Ingalls Trust, Leonard Buck, Shirley Buck, Timothy J. Mauk Trust, Christopher P. Erickson, Natasha L. Erickson, Brandon Q. Martin, Jeffrey S. Smith and Luann M. Smith Trust Number 1, Cheryl D. Zadunik Trust, Sheila K. Fortino, Charles J. Fortino, and the Howard A. Becker Revocable Trust.
Okay,
And that's
thank
it.
you. Okay. All right, I don't think we have any other counsel. So in terms of how we're going to proceed today, this is set for a status conference. Mr. Carey, can you give me an update from plaintiff's side, please?
You don't want a narrative regarding the prayer for relief, I assume. So just procedurally, we've completed service on all the parties we intend to have active as litigants in the case. Some have been defaulted, some have appeared. And our pleadings are in order as far as the plaintiff is concerned. Ms. Keener, I think, is associated with Mr. Haynes.
Yes, Your Honor.
And Mr. Haynes recently asked me to draft a proposed consent judgment on behalf of his clients, which I agreed to do and will do. Mr. Opalewski and I have remained in communication, traded some thoughts on the issues, have not come to any real agreements. We've also just recently submitted to Your Honor, it may not even be before you yet, a stipulation that modestly extends the time to complete discovery and the time to file dispositive motions. I think we've all filed initial disclosures. So I think that amounts to a pretty good description of where the file is at today, Your Honor.
Okay, so Ms. Keener, it sounds like shortly, your firm and your clients will be, their part of this will be resolved. Is that a fair statement?
Yeah, my limited understanding is that Mr. Haynes and Mr. Carey have come to some sort of agreement. And I think Mr. Haynes called it a stipulated dismissal, but I think I understand where he's coming from with the consent judgment, just because we have no issue with what plaintiff is trying to do.
All right, thank you. Mr. Opalewski, and Mr. Carey. So I haven't received that stipulation yet, but I won't have any objection to signing that. Mr. Opalewski, is there anything that you would like the court to do in terms of scheduling going forward, or are you kind of in the same, you're agreeing with Mr. Carey that we'll just proceed based on that stipulation and then maybe set a status conference once the new dates expire?
Yes, that's right, Your Honor. I think, for the limited discovery that I think may end up being necessary here, I think we have enough time to do that. And if not, Mr. Carey and I have always worked well together, so I don't anticipate that will become an issue.
Okay, so I'll sign that stipulation once it's been presented. The court will set this for another status conference at the expiration of that new discovery period. Mr. Carey, are there any other dates that you'd like to set here today?
No, there is not, Your Honor. Thank you for asking.
All right, Mr. Opalewski?
No, Your Honor.
Okay. Since you folks are here, did you have any questions at all?
No, Your Honor.
Okay. All right. I'm Mr. Opalewski, just so you're aware, your clients, the Fortinos, are here in the courtroom, so since they're here, I asked them if they had any questions.
Oh, fantastic. I appreciate that, Your Honor.
All right, thank you. I'll do a status conference order reflecting what we've discussed today, and then the court, once we receive that stipulation, the court will send out a notice of the date and time for that next status conference. And all parties on this case are free to disconnect at this time.
Thank you, Your Honor.
Thank you.
Thank you, counsel.
Exciting.
Sir, under Chuck's iPhone, can you tell me your name, please?
Yeah, it's Charles Hewitt, Your Honor, for the Shaw Stiles pretrial conference, or status conference, I should say.
Okay, all right, very good, thank you. All right, we'll go on the record in Shaw versus Stiles. This is case number 2311441. And if I could have both counsel put your appearances on, please.
Yes, good afternoon, Your Honor. Mr. Carey, Charles Hewitt on behalf of the plaintiff, George Shaw.
Your Honor, William Carey, appearing on behalf of the Stiles defendants in Good afternoon, Chuck.
Good afternoon, Bill. How are you?
Good, thank you.
All right, this is set for a status conference today, as you indicated, Mr. Hewitt. On behalf of the plaintiff, can you tell me where things are at and what you'd like to see going forward in terms of scheduling?
Sure, Judge. My client, Mr. Shaw, well, we had depositions scheduled for this past week of the principal parties, the plaintiff and the defendants. And we had to adjourn those to mid-February because my client is getting daily radiation treatments for cancer. So Mr. Carey was able to put those dates off. And they're set, I think, for the 12th of February, Bill, 12th or 15th, one of the two.
Well, you'd have to ask somebody in my office that knows.
Yeah, I know, it's mid-February, I know that, so.
Yeah.
That's where we're at, Judge.
All right, what are the next dates that you'd like the court, I mean, do you want to just set a status conference for like March?
That would be fine by me. Sure, that'd be good, because I bet by that time, of course, we'll be done with the depositions and find anybody else who might have to be deposed. I don't think so offhand currently, but we'd be in good shape, I think, at that point in time.
I agree with that, Your Honor.
Okay. This case did already go to mediation, right? But that was before the counterclaim was filed.
The case did go to mediation. The
Yeah.
counterclaim was filed after mediation, but in this case, A plus B does not equal C.
Yeah.
Okay.
Yeah, the counter complaint is irrelevant to the fact we couldn't resolve it. It wouldn't change things at all.
Okay, understood.
In fact,
Okay.
probably.
All right, so I'll set this for a status conference in March, and we'll conduct further scheduling at that point. Mr. Hewitt, anything else I can address for your side?
No, we're fine. We're working together well on this, and it's not an overly complicated matter.
Agreed.
Okay. All right, thank you. I'll put that into an order along with the notice of the date and time for that next hearing in March. You're both free to disconnect at this time. Thank you.
Thank you, Judge.
Thank you, Judge. Take care.
Thanks, Chuck. Yep, bye.
Thank you, Bill.
Cook with Max.
Better.
The pie will melt in your mouth. It's amazing. My brother's sushi is good.
All right, Mr. Colin, are you there?
Yes.
Is your video not working? Your video is not on. There we go. Okay,
Yeah, no.
great. Thank you. Okay, looks like we have Mr. Vernon connected as well with Ms. Collins, so we'll go on the record. Where is Mr. Vernon? There he is. Mr. Vernon, are you there?
I thought earlier this thing was.
I can hear you.
Not connected.
I'll log out and log back in. You call the court, let them know. That's what we're doing.
Are you able to hear me, Mr. Vernon?
Did I just send him a message that I could hear him?
Mr. Collin, if you can just hold on the line for a minute, okay?
Okay.
Thank you. Mr. Vernon, are you able to hear me? Mr. Vernon, are you able to hear me?
I don't know. No, there's nothing else to connect. The only reason to plug in is so that we have power. No, really. Let's go into my office. Did you call the court? They know?
I emailed her.
Judge, can you hear me?
Hey, Mr. Vernon?
Hear you now. Can you hear me?
Yep. Okay, good. All right. So we'll go on the record in Colin versus Colin. This is file number 2411622. The record should reflect that all parties are present today by video, along with Mr. Vernon on behalf of plaintiff. This is set for a status conference in this divorce case today. Mr. Vernon, from the plaintiff's side, can you tell me where things are at and what we need to do in terms of scheduling moving forward from your perspective?
So from our perspective, we didn't get a lot accomplished since the court transferred jurisdiction from Judge Burmeister to you. There was some discovery that had been sent out, and there was some answers, but they weren't accompanied by the documents that were additionally requested. So we're going to ask the court to do two things, and that is to reopen discovery so that we can secure those additional documents. And we're asking the court to enter an order that the marital home be appraised, and we can, so that we can accomplish getting that done as well. So we'd ask the court for 60 days to complete that discovery.
Okay. Has the court ordered mediation in this case?
So the court had ordered mediation. It was unsuccessful. I will say that the primary focus of mediation was related to the children, parenting time, and custody issues. We didn't really address property, and frankly, that's the area that hasn't really made much progress at all, simply because we've been focused on the children. So if the court were to reorder it for mediation, specifically related to the property, I think that would be appropriate and probably have some degree of success.
Okay.
I think we would need the answers to the discovery and the appraisal first.
All right. Mr. Colin, how do you want to go forward?
Well, I'd like to go forward by not allowing her to get anything. I've taken a lot of losses.
Okay.
I lost my kids. I lost my family for adultery. She's got the car. She should settle with that.
All right. You understand that generally the court's required to divide assets and debts more or less equally?
Right.
Yeah.
Well, it's not fair what's been happening already. I've already taken major losses. I know I got to give my house up.
Well, nobody's saying you have to give up your house, but you know, again, I don't know what you've lost financially. That might be a factor. So I guess we'll have to hash it out. But outside of saying that you don't want her to get anything, do you have any objection to having mediation, to having an appraisal of the house done? So at least we know how much it's worth.
We wouldn't have a proper appraisal anyway with the winter here.
Oh, why not?
Well, you wouldn't be able to see the ground and the landscaping and the hills and just anything outside, you know, with the snow.
Okay. So are you saying you're not willing to have an appraisal done?
No, not at this time.
And why not?
Well, for one, we haven't even got my kids squared away with that situation that I'm still going through.
Okay, that's a separate issue than dividing up the assets or debts of the marriage. We're talking about property right now. So that's completely separate from what happens with custody. So do you have any other good reason other than it's winter to not have an appraisal done on the house?
I don't think she deserves anything.
Yeah, you told me that, and I get that, but is there any reason other than that that you think an appraisal shouldn't be done?
No.
Okay. All right. So the court's going to order an appraisal done of the house. And if you don't agree with that appraisal, Mr. Colin, you're free to hire your own appraiser. If you disagree with that number, of course. And then the court will have discovery remain open for the next 60 days. and then we'll set it for a status conference at that point. I am inclined to order mediation, although based on Mr. Collins' statements here, I'm not sure how successful that would be. But I would like the parties to at least try that. If I do order mediation, it would be mediation as to property only, so it wouldn't be anything involved with the children, because I'd like the parties, if we do have mediation, to focus on just dividing up property without issues relating to custody being involved in that. But the court will address that at the next status conference, which will have in about 60 days. Mr. Vernon, do you think that's enough time to get the appraisal done?
You know, I haven't had an appraisal done on a property in a while. I don't know how long it's gonna take, but I think 60 days should be reasonable. If it's not, we can certainly get some comps done, at least get a preliminary issue for mediation. And then maybe a little longer for the full appraisal.
Okay.
I would ask in its order to, and I don't know if you want me to draft the order or not, but I would like it, the court's authority to say that the parties will cooperate with that appraisal, so that if we get a day where they have to get into the home, that Mr. Collin will allow them into the home and won't interfere with their efforts to appraise the property.
Yeah, I'll put that into the status conference. I'm going to draft the status conference order, and I'll include that both sides are required to cooperate with the appraisal.
Thank you.
Okay. Mr. Vernon, anything else we need to address today?
No.
All right, Mr. Colin, anything else that you wanted to address today?
You guys are gonna send the date for the appraisal once they get it, or who's gonna do that?
Mr. Vernon, you're going to make arrangements for the appraisal. I'm assuming that the appraiser would be the one contacting Mr. Collin.
That would be my intention, would be to contact the appraisal and have him touch base with Mr. Collin for the appropriate and reasonable days.
Okay. Yeah, so Mr. Collin, it should be the appraiser that'll be in touch with you.
Okay. That should be all.
All right, thank you. That's all for the record today. All parties on this file are free to disconnect at this time.
Thank you. I apologize for the confusion and problem with the video and audio, but thank you for cooperating.
No problem.
Chairs are covered in animal hair.
On the record in Stewart versus Stewart, case number 2411745. And for the record, you're Daniel Stewart, is that correct?
Yes, sir. Yes, Your Honor.
And you're Suzanne?
Yes.
And I have this set for entry of a final judgment of divorce today. Ms. Stewart, is that how you wanted to proceed?
Yes.
And Mr. Stewart as well?
Yes.
Cool. I'm going to have both of you raise your right hands, please. You both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes.
So I'm going to ask each of you a series of questions. The questions that I'm going to be asking each of you are those that I'm required to ask to establish the grounds for divorce under Michigan law. Ms. Stewart, because you were the filing party here, most of my questions will be directed to you. Stewart, you filed a complaint for divorce in this case and you signed that complaint. Is that true?
Yes.
At the time that you signed that complaint, you've been a resident of the state of Michigan for at least 180 days.
Yes.
And you've been a resident of Crawford County for at least 10 days.
Prior to signing?
At the time of signing?
No.
Have you been living in Crawford County at this time?
I moved to Midland County in November of 2023.
November of 2023. This was filed August of this year.
Yes.
You haven't lived in Crawford County since August. Or,
No,
I'm sorry, since November of 2020.
Correct.
Mr. Stewart, have you lived in Crawford County?
Yes.
Were you living here in August of 2024?
Yes.
Thank you. Just need one of you to have been a resident for at least 10 days.
Good.
Ms. Stewart, in the complaint for divorce, there's a statement that indicates that there's been a breakdown of the marriage relationship, such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Is that true when you filed the complaint?
Yes.
Does that remain true today?
Yes.
I'm sorry, I know it's emotional, but I'm not sure we picked up your voice.
Yes.
Are there any children under the age of 18 that were born to or adopted by you during marriage?
No.
Are you currently pregnant?
No.
Under the judgment of divorce, you would not be receiving any alimony or spousal support. You understand that you would be waiving that. Not be able to come back and ask the court for that.
I understand.
And you and Mr. Stewart have divided up all the assets or debts of the marriage already, is that correct?
Yes.
And you do own some real property, and that is on Oak Road and Roscommon, is that correct?
Yes.
For this judgment, Mr. Stewart would be taking over that property and he would be responsible for all the costs associated with that property, is that correct?
Yes.
Mr. Stewart, is that where your residence is now?
Yes.
And is there a mortgage on that property?
Yes.
Both of your names on that mortgage? You've already refinanced it?
Actually, I refinanced, I don't know, a couple months ago. It was paid off.
Oh, okay.
And then I refinanced to get some equity out of it, which is in my name.
Okay, so Miss Stewart is no longer.
She was never on. She was never on it.
I'm not on the refinancing part.
No, you're on the beneficiary part. She has no legal, as far as, responsibility for the mortgage, but if in a case of, something were to happen to me, that property would go to her.
Okay.
I believe that's how it is written.
I just want to make sure that she's not indebted to that property.
No, she has no financial responsibility at all.
Okay, all right. And Ms. Stewart, you already put claim your interest to Mr. Stewart then?
Yeah. Sure.
That's a document that would need to be filed, so.
I don't think there's anything that needs to be done. I'm not on the deed.
You're not on the deed?
No.
Okay. All right.
No.
Thank you. Okay. And there's no other matters regarding the division of any assets or debts, is that correct?
That's correct.
Mr. Stewart, have you heard all the questions that I asked Ms. Stewart?
Yes.
You heard all of her answers.
Yes.
Do you have any reason to believe that any of the answers she gave were untrue?
No.
You also are not going to be receiving any alimony or spousal support as part of the divorce. You understand that you also would be waiving that forever and could not come back later and ask the court for that.
Yes.
And do you agree that there are no issues remaining regarding the division of any assets or debts in the marriage?
I agree.
Stuart, are you asking to have your last name changed?
No.
All right, the court finds that the statutory grounds for divorce have been met by the testimony of both parties. The court will grant the divorce at sign the judgment with today's date. If you would like to get copies of that for your records.
Yeah, they just want to have a seat out of this cheap. Just
Sarah, I'll get you copies for your records. Stuart, do you have any questions at all?
I do not.
Mr. Stewart?
No.
Thank you, that's all for today.
Okay.